In this video, we are going to talk about what happens when you have patent application filed at patent office. Now, first thing first, this is the most important landmark in entire life cycle of patent. So this date of filing is called the priority date or the first filing date, which is crucially important in many scenarios, right from the filing of patent application, the examination stage, the prosecution stage, again having to and fro communication with the patent office, overcoming the prior arts, and then getting patent granted stage, even in the commercialization stage, that you are monetizing your patent application. This earliest priority date, or the priority date, the earlier the better, is going to play a very crucial role for entire life cycle of your patent. So securing that patent application number or patent pending status in itself is a very important stage for the patent life cycle. It is actually the starting of the government procedure. You have filed your patent application, it is logged into patent office now, and although it is private for some time, I mean, if you file the early publication request in India, it would be published after 30 days. So that is after expiry of 31 days, approximately after 1 month it should be published. And although the timeline is not very strict, but then it should happen within a month or so. And the purpose for holding it up for those many days, or let's say about a month, is the patent office checks for the invention. So it is actually checking whether the secrecy directions are required for this particular patent application, and once that decision is done, it would be published. So the ideal scenario is after 30 days. Now the patent pending in itself is having some of the benefits, or what we can say, the rights that you can actually practice for your patent application. Now we'll start with one by one, understanding what patent pending number or patent pending status you can write as a patent pending number, patent application number, or patent pending status. I mean, it means one and the same thing. Or patent filed, you can say, it means one and the same thing. Okay, so the first one is legal protection. Whenever you talk about the patent pending number, it automatically discourages the infringers, assuming that your product is in the market and you are writing a patent application number or patent pending number. The people who want to copy your invention would be not very keen to do that, because it's a straightforward message that the patent has been filed and we have the legal ownership over it, and our patent would be granted soon, and then whatever you do is kind of an infringement and there would be a lawsuit. So people would not be very encouraged to just take it and copy it when we see the patent pending number. That's the main benefit. I mean, it's kind of a legal protection right away. You actually position your product. It's like positioning it as expertise in the market. Like let's take an example of a e-commerce website like Amazon. When we say hundreds of products and few products have, or one product has patent application number over it, so it's certainly seen as something which is having some extraordinary feature, or as a market leader, or maybe doing some research oriented stuff there, must be a better product. So you position yourself in the market in a better way when you have patent pending uh, uh, mentioned on your product or service. So you also get interest from investors when you have filed a patent application, because naturally people who are investing in your technology, your field, or your product or service would see that your patent would give them 20 years of benefit of having a monopolistic service or product that they should be investing in. So investors would definitely consider you very strongly if you have patent filed or patent pending for your invention. Then you do have licensing opportunities as well. So when you say patent pending, ideally the licensing should happen after the grant of patent, but however, there are scenarios wherein even after filing the patent application, you can actually sell your invention. I mean, sell the patent application itself, or you can license it to the third party, or maybe multiple parties if it is non-exclusive license, and still this can go as a licensing opportunity. So filing a patent application gives you the legal right to license it somehow. And you can actually have a better negotiation power, a leverage for negotiating with parties when you have patent application filed for it. It naturally means that you own the monopoly, or let's say you own a very significant legal right for that particular invention, and you stand in a better position to negotiate for whatever deal you are talking through. Then it is a patent application filed in India. However, it can be a foundation of filing multiple patent applications. The same application can be filed in multiple countries and can become a global protection. If not global, you can selectively choose few countries or whatever number of countries, and same patent can go in multiple countries. Let's say 10, 15, 20, and still your base application from India holds the ground for it. I mean, that would be the first filing. That would be the priority date, which is important. So this can be a basis for multiple countries protection for your invention. Again, patent pending is important here. So naturally your question would be, okay, now I have filed my patent application, what things I can undertake or what things I can do when I have the patent pending number, or let's say the patent has been filed. First thing first, we have to understand that 95 or let's say 90% of the things you wanted to do as an entrepreneur, as an innovator, or as a professional by filing a patent application, you can do without any worry, because you don't need to wait for grant of patent for many things. For example, uh, if you want to promote your product, you want to start selling it online, or maybe just dispatch your products to your customers, have some sessions about it, maybe talk about it openly, IEEE presentations, research papers, whatever, or you writing blog about it, be vocal about it, do partnerships, tie-ups, raise funds for it. You can do anything without any worry of it would be it will be copied, or the main worry is somebody would steal my invention. So that is gone because you have filed the patent application already. It's at patent office, although not published, but then your filing date is secured. So the main thing we have to understand is 95% of the things you wanted to do, uh, you can start doing even at the stage of patent filed or patent application has been filed at patent office. You don't need to wait for grant of patent to do most of the things. The only thing you probably need to wait for grant of patent is filing a case against infringers. Even for that matter, I mean, there is kind of inferred protection wherein you can even the patent is filed or published, you can intimate somebody who is infringing your product that okay, this is patent filed, it is published also, and in a very quick time we would be getting a patent granted, and whatever you are doing you have to stop it because it is infringement, it is our invention. And let's assume that the company or whoever is infringer continues to do that, and later on you get the patent and you file the lawsuit. The court may decide that during the period from when you have informed them, they can actually allow the charges, or what we can say damages, to be given to you even before the period of grant of patent. So in a way, I mean, it's a tricky situation, there are lots of ifs and buts. However, uh, long story short, you can have that protection, inferred protection, right from the filing date itself, or right from the publication date itself. So that is one of the important thing to remember. So things you can do, you can actually market your product, you can start selling it, you can make engagements with investors or banks, you can have the what we can say tie-ups, different types for businesses, distributorship and everything. You can do conferences, be vocal about it, start marketing it, start speaking about it in the media. You can have presentations, you can plan market entry, and continue to develop your invention without much botheration about who will see it and who will copy it. So that is one of the, what we can say, peace of mind we get with the filing of the patent application, because uh, you are free from the fear. Now somebody will see it and somebody will track it. Now what to do with the application number? Now patent application number should be mentioned, or it is a discretionary, I mean it's not mandatory, but it is good to mention it on the product or service that you are selling. That sends a message to the competitors. However, that particular number can be used for many purposes. First thing first, you can track your patent application. How to track a patent application? There are different guidelines and videos also. You can actually have that number searched in Google, and you can check the status of your patent application, in which stage it is. Now, apart from tracking and references, you can also validate an authority with regards to this. So when you search the patent application number, you will get the published patent application, and you can validate that, okay, this is my patent application. You can send it to the different authorities in case you need to raise the funding, or to talk to the investors or maybe channel partners, whatever. It is a legal documentation because it is published on the patent office, so it becomes kind of a legal ownership of your invention. Things you need to take care of is, now it would be published. I hope it is published already within 30 days. If not, it would be published after filing. Within 1 month it should be published, and after publication within 3 to 4 months, or sometimes it takes longer time, sometimes it is happening quicker depending on the pendency at patent office. The examination report would be received. That is called FER, first examination report. Now here, what is happening is our patent application is being reviewed by the government uh, patent office examiners, and they will come up with the report of what objections they feel that they have on our patent application. Now, generally, the examination report would be a longer document with all the objections listed, like D1, D2, D3 prior arts, and why they feel the claims are not novel or inventive, or whatever the formal requirements of the patent office. If in case we are not complying to it, they will raise an objection and ask us to correct it before proceeding. So, ideal way to respond to the objections. This is happening in 4 to 4, 5, 6 months from the filing of the patent application. Just giving you the glimpse, like what you can expect happening later. Like the ideal way to do it is, patent attorneys would review the objections, will send it to you for distinguishing the D1, D2, D3 prior art with our invention. Any technical suggestions if you have, but the attorney team is capable enough to write the response to the objections, and that is called response to FER, and it will be filed in patent office. Although the timeline for responding is quite extensive, I mean, we can take 6 months to respond to the first examination report, but then generally it is done quickly within 15-20 days, so that we don't lose time. Once the response is filed, the two things can happen. One is patent office accepts the response, or do whatever corrections they want to do, or just dispatch or rather dispose of the case. That means the patent would be granted, or they would be allotting us a hearing. The patent cannot be rejected without a hearing. So hearing is another chance wherein the similar objections or maybe new objections are given to us, and it is like a Google Meet or one-on-one discussion with patent officials, generally controllers or associate controllers, team members from government patent office, and the patent attorneys. You as an inventor may want to join that hearing, provided you want to add some technical inputs or you understand the objections and then you are capable of arguing with it. But generally, the patent attorney team handles, the patent agents and patent attorneys handle the hearing part of it, or what can be done so that it would be granted. Sometimes it is to and fro regarding the scope of the invention, and some elements can be added from the dependent claim into independent claim. I mean, we are just talking about very specific case, but generally, more or less, it's about the corrections into the claims and changing or deleting of the claims, and then the patent should be granted in most of the cases. However, conditions apply. I mean, star is there. The patent can be rejected also, although the percentage is not quite high. But patents which are like poorly filed or not following the patent law, or having very strong prior arts wherein the novelty is absolutely destroyed, then the patent can be rejected as well. So, long story short, this is what you can expect in next 4 to 5 months, 8 months, and the patent should be granted well within 1 year if everything happens as per plan. Now, if the hearing is not happening, the patent could be granted even before 1 year, like in 6, 7 months also. That's very normal to see that. And in 30% of the cases, hearing won't happening. I mean, hearing won't be happening if patent office is satisfied with the claims that you have written and the arguments if you have provided for the FER, it would be granted straight away without even requiring hearing. Now, once the patent is granted, you should be also keeping a close eye on the renewals. Ideally, the first 2 years fees is paid, first 3 years fees is paid, but then next 3 to 5 years, you can pay the fees in chunks also, and you will get, let's say, 10% discount on the renewal fees. It's not much. It's in like for the first year or third year, it is 800 rupees or something, and it slowly gets incremented, year by year. So it's very affordable to renew the patent, the granted patent at patent office. The chart for the fees can be seen at government patent office itself. If you want, I can share the link in the video itself at the description. I hope this video able to provide some value to you with regards to patent filing, the after patent has been filed, what happens next, and then patent pending status, patent application number, or patent filed status, the benefits of it, the advantages, your rights, and maybe your responsibilities with regards to renewals and keeping an eye on the patent process. So hope you receive some value out of it. Thank you so much for your time. Take care.